Now before we go on, I should mention right here that, as we said earlier, that the parties can agree to anything they want in the contract, and that will take the place of the CISG. There's another aspect of the CISG that we've not discussed yet, and that is the freedom to modify or amend the contract. And the CISG says that any agreement can be changed or ended merely through agreement of the parties. Now that's a big change from the common law from the UCC, which requires some sort of consideration to be paid in order to change a contract. But under the CISG, the lack of consideration is irrelevant. The parties can simply agree to change the contract without the need to pay an additional amount. So let's turn now to remedies, the remedies for the breach of the contract. Now, breach of a contract, as we said, refers to a party's non-performance of a contract obligation. Now, under the CISG, there are actually two types of breach. And we had these same two types of breach under the common law and the UCC as well, or somewhat similar concepts. Now, there are two types of breach. And the first is what we refer to as fundamental breach or material breach. In this case, a breach of a contract is fundamental if it results in such a detriment to the other party as to deprive that party of what it was entitled to expect under the contract. So there's two aspects to a fundamental breach, and that is there must be a detriment to the non-breaching party, and the breach must substantially deprive the non-breaching party of the benefit of the contract. So in a sale of goods transaction, what would be the difference between a fundamental breach and the other type of breach, which we call simple breach, or any breach that is less than fundamental? Well, if two parties agree to a shipment of bicycle frames, that a manufacturer in China is going to manufacture bicycle frames and send them to an assembler, a construction company, a seller of bicycles in Kansas, and say they have a contract that calls for the shipment of 100 bicycle frames. Well, if the frames are never shipped, that's a fundamental breach. The non-breaching party, in this case the company in Kansas, would have missed the benefit of the bargain. Say instead of 100 frames, the manufacturer in China only ships 12 frames. Again, probably fundamental breach because the non-breaching party, the company in Kansas, is deprived of the benefit of the bargain. Now say instead of 100 frames, the Chinese manufacturer ships 98 frames. Well, that's mostly what the contract called for. And in that case, that would not be fundamental breach. That would be called simple breach. Simple breach meaning a breach that is less than fundamental. So get these two notions. Now there's not a clear delineation between what's a fundamental breach and what's a simple breach. On your test, on your exam, I'll make it quite clear whether it's fundamental or simple, but you'll need to know that. And again, if you recall from your introductory legal studies course, we call this material breach and simple breach. So the requirements for a fundamental breach would be something along a serious breach, a seller's failure or refusal to ship, or say a buyer's refusal to pay. A breach less than fundamental would be something like a late shipment. Maybe the frames in our situation, in our hypothetical, will be delivered in October, on October 15th, but instead they were delivered on October 22nd. Well, a late shipment, probably less than a fundamental breach, would simply be a simple breach. Now there's another concept here this is unique to the CISG, and that's called the knock-frist period. Now, in the event of a dispute, the CISG, the authors, the drafters of the CISG, want the parties to stay in a contract. they would prefer that the parties not automatically go to dispute resolution in the event of a simple breach. So, in the event of a simple breach, which could be delivery of non-conforming goods or late shipment or late delivery, the seller can request to the buyer to grant a short extension of time in order for the seller to remove itself from breach, to cure the problem. Sometimes sellers just need a little more time in order to perform, and the CISG provides for a cooling off period, what we call the not frisk period. If the breach is fundamental, then the buyer is under no obligation to grant an extension of time. If the breach is simple breach, the buyer that could be cured by performance, the buyer should grant the not frisk period. So this is a German concept. Now this not frisk period is directed only to the parties, not to a judge or an arbitrator. It's not designed to be a penalty. It's not a remedy. The judge cannot impose a not frisk period. Instead, the not frisk period is about allowing the parties to come together to keep the contract in place to avoid the difficulties of resolving the dispute in an arbitration panel or in front of a judge. It's not a seller's right. It's meant to be a companion to the other types of remedies.